Swayam Prabha. Digital India. Educated India.
Welcome to all of you. We have been discussing about tariff, what are the powers of the appropriate commission to decide on the regulations on tariff, how the appropriate commission determines tariff under section 62, and in 2003 Act the lawmakers have also given a choice to the buyer and seller to decide on tariff with mutual agreement. So, one way of deciding the tariff is to look for the notification through the appropriate commission under section 62, and other is to go for competitive bidding. So, in today's session we will discuss that what are the laws with regard to competitive bidding, what is power purchase agreement, and what is the legislative scheme, and also we will also look into the some of the cases that how the code has decided, code has said on the section 63 of the Act. Now, if you look at the language of section 63, which allows determination of tariff through a bidding process, it starts with a non-obstinate clause. It says notwithstanding anything provided under section 62. So, this is very clear that the lawmakers have given an alternate route. It has suggested an alternate route for determining tariff apart from what appropriate commission would suggest or would determine or would fix. So, it is an exception. Exception from what? Exception from the very general power which is given to the appropriate commission to determine tariff under section 62. So, section 63 says that tariff determination is possible through competitive bidding. But then point to be noted here, and as a law student we need to be very careful when you read the provisions of the Act. It says notwithstanding anything under section 62, meaning thereby that the exception which has been carved out under section 63 is only in relation to section 62, not in general. So, even if the parties are allowed to mutually decide on tariff, when I say mutually decide on tariff, I do not mean that MOU. Mutually decide on tariff, I mean through the competitive bidding process, where there is a bid going on. That is what I clarify very vehemently, very clearly. So, if it is been done through a bidding process, then the responsibility of the appropriate commission is to just see that whether the bidding process is carried out in accordance with the guidelines issued by the central government or not. That is what is the responsibility of the appropriate commission. And please do take note of this fact that it is not a case where there is complete freedom given to the bidder. Complete freedom is not given to the bidder, because they have to comply with the guidelines issued by the central government. And guidelines of the central government, if you go through, you find that competitiveness is the essence, reasonable pricing is the essence. So, it is not a free choice, and that is why again I reiterate that why this sector is considered as one of the regulated sectors. So, once the appropriate commission satisfies that yes, the whole bidding process has taken place as per the guidelines suggested and it has been done in a very transparent manner, then look at the language. Then what the commission does? It adopts the tariff. It does not determine the tariff. Determination is under section 62. Under section 62, the appropriate commission determines as per the regulation notified by the commission. But then under section 63, what it does? It simply approves, it adopts, it simply examines that whether what has been agreed upon is being done fairly or not. So, its appropriate commission has a role. It has a role to examine that whether transparent process of bidding has been followed or not, and it is also that whether the transparent process has been followed as per the guidelines issued by the central government. That also is important. Now, in the bidding process, the commission does not look into does not determine the cost element. If you look at it, if you recall, we discussed in the determination of tariff by commission under section 62 that cost plus is a core of the methodology of determining the or fixing the tariff. Here cost element is not important. The very nature of competitive bidding is such that where cost escalation claims and no such clause is allowed to be operational. So, that is something which one can say relates to the risk factor. Risk factor is there. Whereas, under section 62, if you look at it, the risk factor is minimal, because cost is already been considered there for determining the value. So, when section 63 says that central government has to formulate, when central government has to formulate the guidelines, the standard bid documents, any deviation from that document would not be permitted unless and until the commission approves the same. So, you can very well visualize a proposition that appropriate commission is not merely acting as a post office. It is not just it is receiving a document and passing it to the successful bidder. Appropriate commission in the scheme of section 63 plays a very defined role. What is the defined role? An oversight body to see that whether the process has been done following all the norms as suggested by the central government. And that is why section 63 is not to be understood as a standalone provision. It is not that section 63 in a way operates the complete field of competitive bidding and arriving at the tariff for the joining units and the licensees or the procurer. Section 63 is only subject to section 62 and not subject to section 61 or not subject to other provisions. So, notwithstanding when you look at it, not subject to, it is notwithstanding. So, section 63 is only notwithstanding in relation to section 62, meaning thereby that the regulations which are being framed under section 61 still influences the bidding process. That regulation has to be considered in the bidding process, and I will give you one example to substantiate this point. And what is that example? The example is that if consumers' interest is not catered through that bidding process, even if all the necessary procedural requirements are being followed, the bidding process would be bad in the eyes of law. So, 63 allows competitive bidding, it allows tariff fixation between the parties, but not independent from the scheme of the act. That is what is not allowed, and that is why very rightly said it is not a standalone provision. It is not that when it comes to bidding you look at only 63 and try to find out whether it has been done as per the law or not. You have to also look at section 61. So, power procurement, as I said, it has been done through two processes. One is section 62, which we have already discussed, where it has been done through MOU, where cost plus methodology is being followed, and other is competitive bidding. For competitive bidding, what you see, there are two situations. One situation is where the developer, the generating unit, decide on that what kind of generating units the developer wants to establish, solar, thermal, gas, where it wants to establish, and the whole thing would be driven by how it wants to compete in the market with other competitors. So, their fuel, location, technology all are not specified, they are not specified. That is something which is not the developer which is predetermining in a sense for the purpose of bidding. So, project developer bids for the portion of total power of generated, and it is the responsibility of the bidder to take all clearances from the government offices, to take the approvals, be it environmental clearances, be it other necessary approvals from the technical approvals on the technical fronts. So, this kind of approach you would find more where there is a resource constant in terms of fuel, and no doubt the way it has been structured, one can really make out that such bidding entails the higher risk for developer and lower risk for the state, because the state has not much to lose. The second route is the route where developers are expected to bid on basis of a specified fuel source and location. State suggests, okay, you come forward, install a solar power plant, you come forward, install a thermal power plant, where government or procurer which is calling for the bids, and then it is the government or the procurer assist the bidder to get the necessary clearances and approvals, and you would find that this kind of bidding process is applicable where there are fuel resources available, or in coastal areas where it is possible, where it is very feasible to get the imported fuel, and such arrangements certainly would entail higher risk for the procurer and the lower risk for the developer. Now, in this regard, when you look at it, there are certain observations which are being made. All India Power Engineering Federation, Session Power 2016, where it says that yes, it is true that in the bidding process tariff is being determined through the identification of L1, through the identification of the successful bidder, but at any later point of time situation arises to alter that tariff, then such alteration would be possible only when it is well within the scheme of power purchase agreements. Anything which is going beyond that then the commission will look into it that whether consumers' interest is being catered or not. If consumers' interest is not being catered, where because of the scenario, change scenario, the consumers are going to be asked to pay extra, the burden is shifted to consumer, appropriate commission can very well examine that whether it would be against the scheme of section 61 of the act or not. So, that is what an important observation the Supreme Court has made in this case. This is something which is a very important case, Energy Watchdog versus CERC, Central Electricity Regulatory Commission. This decided by Supreme Court in 2017, wherein important question was raised with regard to the bidding process and whether the successful bidder can enhance the tariff, increase the tariff in the light of change in the cost of fuel, and how that change in the cost of fuel is to be seen in terms of power purchase agreement. Should it be seen as a change in law? Should it be seen as a force majeure? Now, what the court has said in this case, that section 63 does not completely keep the power of the appropriate commission away from the whole scheme. It is not that they are completely ruled out. 61, which talks about terms and conditions, which talks about terms and regulations, are to be considered, and 79, which talks about the functions of the commission, there also important function to the commission interested is tariff fixation. So, 63 has to be read in the light of 61 and 79, and as I said that 63 does not use this word notwithstanding anything contained in the act. It says notwithstanding anything in section 62. So, it cannot be argued that commission shall have no role to play in adjustment of pricing. In this case, there was escalation on the pricing which was to be imported from Indonesia. The coal was to be imported from Indonesia, and there was a price hike done by the Indonesia, and because of that price hike, it was becoming unfeasible for the developer to supply the electricity on a price which has been finalized through a bidding process, and therefore, they pleaded for change in the tariff. They indicated that it should be considered as change in law, and therefore, necessary amendment should be allowed to be done in power purchase agreement. Now, the court in this case has said yes, when you look at the change in price on the imported fuel, it has disturbed the whole arrangement, but then that cannot be considered to be change in law which is happening in other jurisdiction. However, the court has clarified that the change in the allocation policy of coal blocks in India certainly amounts to change in law, and on this premise the court has very well indicated that necessary revisiting of the price fixation is allowed. That is something which should be considered. So, the idea of compensatory tariff and all was taken into account. So, an important law or legal development has been discussed in this case of Energy Watchdog. Another important case where the tribunal was asked that whether appropriate commission can compel the procurer to get the electricity from the generating unit which was not successful in bidding process. In this case, the appropriate commission has asked the distribution licensee to get the electricity from Noida, from the other company which has a lower tariff, but then which was not a successful bidder, under the bidding process. Now, the court looked into the scheme of section 63. Court said that the scheme of section 63 is very clear. What is that? That appropriate commission adopts the price, adopts the tariff which has been agreed through a bidding process, and therefore, it cannot really make a change which shall amount to a sort of backdoor entry. So, if SR Power has become a successful bidder, Noida Power should get electricity from SR Power and not to get from the other company which has been offering price on a lower tariff. So, the tribunal has said that the idea of competitive bidding is to discover the tariff, and that is what needs to be adopted. That is what is the essence of section 63. And then you have another case where again the appropriate commission suggested for renegotiation of tariff between the developer and the procurer, and tribunal was asked to examine that this very exercise of power by the commission is as per the law or not. And the tribunal, while examining the scheme of section 63, makes this point very clear, said that under section 63 there is no question of regulatory commission asking the bidder and the joining units to renegotiate the power purchase agreement. What has been determined through a competitive bidding, that must be respected, that must be honored. So, the role of the commission is only to ensure that the process followed in the competitive bidding is transparent and as per the overall scheme of section 61 or not. If answer is yes, the role of the commission ceases to be in existence for that issue, for that particular point. And thus, in this case, the tribunal has nullified the direction of the regulatory commission to renegotiate the agreement entered through the competitive bidding between the developer and the bidder. So, you look at it the way the court has accorded the sanctity to competitive bidding and facilitating it as a successful alternate to tariff determination process, and that basically is the larger objective of the act, that let the tariff be fixed through the competitive process, so that ultimately the consumer will get benefited by getting electricity on a reasonable price. Thank you very much.